you all so much for coming. So I'm going to talk a little bit about school segregation law in Oklahoma Territory. Before I start, I want to acknowledge the Oklahoma Historical Society and thank them for this opportunity to talk about my research. So I'll begin with a letter. On June 10th, 1904, T.H. Honeybus wrote a letter to the Territorial Governor of Oklahoma. In it, he stated, "As a tax-paying citizen of Oklahoma, though black, I certainly have rights that are not being recognized. I do not make preposterous or unreasonable demands, but only ask that some reasonable provisions be made to afford my children a chance for at least a limited schooling, and I am held off by the school officials." When I read this letter in the archives at the Department of Libraries of Oklahoma, I didn't realize the enormity of this statement. I at first didn't realize that what he was making claim to was a constitutional right to education. This letter represented not only his concerns, but the concerns of many other black Oklahomans during the territorial years who were concerned that their children were being shut out of schools. In my career as an educator in Oklahoma, I had always known that there were inherent inequities in educational access. And I had always wondered what the source of that inequity was. And as I've done my research, I found that the concerns of Mr. Honeybus were the concerns of many black Oklahomans around rural areas and small rural communities where segregation law was denying them access to full education for their children. So what I want to do in this talk today is make a connection between Mr. Honeybus's demands and his claims to rights as a taxpayer and connect that to a broader story about not only the letter writers, these black Oklahomans who are writing to the Territorial Attorney General and Governor making demands for schools, but also the many black Oklahomans who brought court cases in district courts that were essentially federal courts in Oklahoma Territory. They had judges who were appointed by the President of the United States because we were a territory. And so here in Oklahoma, there were more court challenges raised than in any other state at the time. Over 47 that I count in my research. And yet there's been no comprehensive study of these legal challenges or the demands raised in the letters like the one T.H. Honeybus wrote. This history has been largely invisible. Despite the ways that I believe this history can inform our understanding of the rights perceptions of black Oklahomans and the power of the federal government to protect those rights. I begin my talk with this letter because I think it places Oklahoma as a site of this broader battle for civil rights. And I also think that the letter and a lot of the work that I do is to try to give voice to black citizens who had a contemporary understanding of their educational rights. Before I go into it, when I'm doing this, it's like scrolling ahead. I want to, begin by talking about the fact that I'm focusing in on people who came to Oklahoma in land runs and lotteries, and these were people who had hopes that they would gain access to land ownership, and I want to acknowledge that that land ownership came at a huge collective loss to the tribal nations who were already in this space. My work focuses on these black pioneers, but I just want to acknowledge that this land was, the land of indigenous nations before. So I just want to say that. And I also want to give a little bit of a heads up. Sometimes I'll have photos of newspapers that have words that we wouldn't use now. I won't use them, but I just want to kind of give that heads up. So the questions that I raise in my research is really linking my studies about black educational lawsuits and making claims of education is marrying this to a broader question about, is education a right? What is the role of the federal government in protecting the rights of all of its citizens and their access to a quality education? What role do the courts play in determining that access? And then how do contingent or liminal spaces like Oklahoma Territory during its territorial years, how do they help inform our understanding of the ways in which racial hierarchy is established and maintained? And I look specifically at the ways education is used as that, in that project. My research addresses through an examination of Oklahoma Territory and Black Oklahomans who fought against their curtailment of their right to education. And here, it shows citizens who were able to make that claim of a right to education directly to the federal government because they were appearing essentially in federal courts. This is a brief topic overview. I'm going to give a little bit of a background. I am an educational historian by trade, and so I'll give a little bit of a talk about education as a federal right. Then I want to go into Oklahoma as a case study, and then finally end on the broader significance of my work. So my methodology, the thing that I do is I am a historian. I want to use archival research to tell important stories about the way law, society, and race interact. Most important in my research is locating a federal right status for education. And I do that by looking at a federal intent to provide access for education to all children. I believe my work on Oklahoma Territory helps inform us because it was the space that was overseen by the federal government. So I have done archival work here in Oklahoma at the Oklahoma Department of Libraries. I've also gone to the National Archives in Fort Worth. I've gone to the National Archives in Maryland. And also, most recently, I've been working in the NAACP papers in the Library of Congress in Washington, D.C., all looking into Oklahoma. And all that is to do, what I'm trying to do is use this archival research in order to help inform the connections that we can make between the importance of Oklahoma Territory and its role in establishing kind of a historical record of the ways in which people perceived their educational rights. So I've also gone into district court files, many of which are in danger of being lost to history. These are housed in courthouses around our state. Some were being actively thrown away when a museum person saw and rescued them, and they're now housed at the Museum of the Great Plains in Lawton. So I really see this as very crucial work to recover these documents. When legal historians do work on district court cases, it's very challenging work. Not a lot of scholarship deals with district court cases. Everybody is interested in Supreme Court cases or things that even went to like a state Supreme Court. But when you start digging into court reporters, even those are it's inconsistent. Sometimes it's very hard to know if these cases, they don't have school district in their title. It's often an individual suing another set of individuals who were the superintendent or the school board. So sometimes it's very hard to locate these cases, but that's been the work that I've been doing for the last 7 years. I want to do this because I want to preserve and bring to light these stories of Black Oklahomans who felt like they were owed an educational access for their children. So I'm going to talk a little bit about education as a federal right. So my work engages with scholarship that looks into federal education policy in the 19th and 20th century, and I am really looking to link my work into this broader question and debate about whether there is a fundamental right to education. In 1974, the United States Supreme Court ruled that the right to be educated was neither explicitly or implicitly found in the Constitution. And the lasting impact on schools has been profound of this decision. Post San Antonio, many scholars have sought to find ways that we can document that there was an implied federal right to education. So we know in the crafting of the Constitution, while some entities were set up, like the post office, they made a deliberate decision to appease southern slaveholding states to not include the setting up of common schools. This puts us as an outlier in other Western nations that we don't have an enshrined right to education encoded in our Constitution. So historians and legal scholars have tried to look at other documents that might find a way to show the Supreme Court that there was an implied right to education. Some people say that that right came in the post-Civil War amendments, the 14th, 15th, and 16th, where they would argue that education is part of broader citizenship rights that were endowed in those later Reconstruction era amendments. Other people argue that it's your right as a taxpayer that ensures your access to the rights to schools, since you are paying taxes for those schools. The work of James Anderson on Black education in the South reveals that a lot of times Black people were taxed twice. They were paying taxes for schools that their children were locked out of, and then they were having to pay again for schools that were specifically for their children. So I look to provide my small contribution to this argument is to really look at court cases and to look at the court cases here in Territorial, Oklahoma, because here in Oklahoma, many people raised constitutional claims that elsewhere in the country were unlikely to be successful. And so I believe there were conditions here that allowed that success to happen. Other scholars looking for a federal intent look to other federal policies of this era, treaties with Indian nations, the rise of the Indian boarding school system. One scholar looks at organic and enabling acts, all of which required the building of schools. So I believe that my work on Oklahoma Territory, it's one of the few studies that really hones in on legal challenges held in a territorial space. This time period in which we were a territory was a critical period, not only for Black rights and the enshrinement of rights, but basically in Oklahoma Territory, we extended the protections of Reconstruction with federally appointed judiciary and governor long past the way that was in the South. So I argue that this space is a very unique space that allows us to see different things than other states. And I'm preaching to the choir because I have an Oklahoma audience, but sometimes when I present, nationally, people are like, oh, Oklahoma, I've never even thought of that. So that brings me to my next point about Oklahoma as a critical case study as we explore the notion of educational rights. So again, I'm in an Oklahoma crowd, so I won't give you a deep dive into Oklahoma history. I know you all probably know this, but Oklahoma Territory was originally envisioned as a space to give sovereign Indian nations, many of whom were forcibly removed into the space, like a place to be. In the renegotiation of the treaties with the tribal nations after the Civil War, this meant the opening of land through the Homestead Act, which was, of course, a great collective loss to the tribal nations. But through these renegotiated treaties, tribal citizenship was conferred on the formerly enslaved people of those tribes. And with citizenship rights came access to land. First through informal occupancy rights and then through formal allotment. After the opening of Oklahoma Territory, Blacks envisioned the state as a place of potential, a Black Eden, potentially an all-Black state. Ralph Ellison, who grew up here, our probably most famous writer, who came from Oklahoma, described it as a magnet for individuals who had found disappointment in the older area of the country, white as well as Black. So this is why I argue that the unique conditions here in Oklahoma make it a valuable case study. Like I said before, its territorial status meant that it fell under federal oversight. The appointment of the governor and the judiciary fell to the President of the United States, who all but 4 years of the territorial years was a Republican. So that meant largely Northern Republicans were being appointed by Republican presidents into roles of leadership, so governor and the judges. Another thing that Oklahoma has that marks it as different is educational access. Because of the network of schools that the tribal nations had already had brought with them in many cases and then established once they were here, there was a remarkable infrastructure for education, one that education historians are only just now starting to really understand. But of course, the tribal nations have long understood. There was also educational access on military outposts. So there were policies of literacy instruction for all soldiers, including the all-Black regiment of Buffalo soldiers who were stationed in the western forts. And there was also access to land. Here was the promise of land, 160 acres to anyone who could claim and maintain it. So this marks Oklahoma as unique. Though there were other western territories that had promise of land, Oklahoma, with its close proximity to Texas and other southern states, made it an attractive space for people to move to. And finally, Oklahoma had, I would argue, though people maybe from further west don't agree, a Western identity. We were not truly North. We were not truly Southern. This is possibly why we got left off the Rand McNally Atlas one year, because what is our regional identity? We have a complex set of racial dynamics in this space. One scholar says this is like the whole of the United States compressed into one area, and then you have our state formation happening kind of on fast forward with all the different groups that were here. So while some Californians or Coloradans might dispute it, I would argue we have a Western identity. And that allowed for a more fluid and dynamic interplay between different racial groups. Indeed, when Oklahoma Territory was opened, the earliest schools were integrated. There was not a segregation policy until the first legislative session. And many schools, we know from kind of firsthand accounts and other letters that I've read, many schools remained integrated despite segregation laws. And small rural communities, I've read letters where a person's like, someone's telling me we have to build a whole separate school. Why would we do that? We can barely afford one school. And the Territorial Attorney General is writing them back saying, yes, sadly, you do have to build a separate school. And they're like, ugh. So some communities came up with creative alternatives. They had a teacher who would teach one room here and one room here, but they would stand between the rooms. So my study explores this time period through examining the court cases that not only tried to challenge the segregation laws themselves, but also tried to demand educational access when segregation laws were passed and communities refused to build schools. So that's what my work is looking at. And this is a letter, a photograph that I found in my research. The man up top is the teacher. He's Tom Willis. He was a legislator. He later went from being a teacher to being a lawyer, and though he was a populist and kind of part of the Democrat populist movement, when they were trying to pass segregation law, he was saying, I don't know, this just doesn't feel quite right to me. And then I was kind of researching him, and here we go. He was a teacher in clearly an integrated schoolhouse. So this is yet more evidence of this integrated education that was happening. So I began my talk with a letter from T.H. Honeybus, who was a barber and had a very prosperous business. Apparently the best baths you could have in Manitou were to be had at the Honeybus barber shop. And he wrote back and forth between the Territorial Attorney General and Governor demanding access for his children. His children had been shut out of schools for multiple years in the town of Manitou. And, you know, sometimes I get into reading the letters and I just want to know what happened in this case. And so you can see that the Attorney General and the Governor are intervening on his behalf. He also clearly has some people in his community who are talking on his behalf and writing to the county superintendent. And so then I found this newspaper article that shows that Kiowa County ended up having one school for Black students, and they called it the Honeybus School. So now we can know that he was successful and that the people who were supporting him were able to gain that educational access for his children. But I think his letter speaks to the condition for a lot of Black Oklahomans who got their land through lottery, who were then sometimes the only Black family for miles and miles around. And the segregation law would say, oh, if there's 3 children, you have to build a school. And then it was 8 children, then it was 10 children. And so in his community's case, they didn't meet the threshold. And so, you know, it was going to be, you know, back and forth with the county superintendent as to whether they would have to build a school at all. Mrs. Amos Birch in Geary also had lengthy correspondence with the governor and the attorney general, and her letters reveal that she was clearly aware of the logistics of the law, and she also knew her rights as a citizen. She wrote, I am a citizen, I pay my taxes, all my 9 children have been bred and born in this Oklahoma and Texas, and I know the school law reads that a child cannot be forced to go over 3.5 miles. So she knew the logistics of the law and was working consistently to demand access for her children. And you can see her quotation here. Writing the next school year, my children are shut out. So they were trying to make her kids go 3.5 miles, and she was saying, we only have 1 team of horses, I can't send them. So these letters, I think, show not only Black citizens' willingness to stand up for their rights as they understood them in the laws and the evolving segregation laws, but it also shows a responsiveness on the part of the territorial governor and attorney general who intervened and issued opinions that were legally binding. Some of the cases were passed on to the U.S. attorney, the U.S. district attorneys who were present in the space during the territorial years. So clearly, there was a willingness to protect Black citizens' right to education, and that there would be, in territorial Oklahoma, no denial of education on the basis of race. So that's the letters to the Attorney General that I study, but I also primarily study cases brought by Black families demanding educational access. So I look at these cases. This is a partial list. There are over 47 cases that I have uncovered so far. There could be more out there. 3 of these cases were appealed to the Territorial Supreme Court. The very first case that was brought was argued by the Territorial Attorney General on behalf of the Black family, the Wilsons. So that's that very first case up there. The governor himself declared that the law was unconstitutional and would not stand, so the law segregating schools. This first case was brought in 1891, just 2 years after the opening of the territory. The story is that John Wilson and his wife Bell attempted to enroll their two children, Eva and Janetta, at the school that they had attended the year before when they were turned away by their teacher because of the recent legislation that had passed segregating schools by a county option, meaning that counties had to vote, each county, whether to segregate or not, and Logan County had voted to segregate. This case was taken up by the Territorial Attorney General, who had been himself a legislator in that first session. He had vehemently fought against the law passing. If you go into the legislative records, you can see him fighting and fighting each iteration of the segregation law. And so I think it's remarkable that then, when he was appointed Territorial Attorney General, he took up a case challenging the constitutionality of that law. And this is notable because a legal scholar of educational access law says that there are only 2 instances where a state attorney general took up the case of black litigants, and this would be the third instance of this, because he didn't list this case as one of them. And in my studies, I would say this is the only case of a territorial attorney general taking up the case of black litigants. So it's a very remarkable case. They won in lower courts and then were defeated in the Supreme Court of the Territory of Oklahoma, meaning that segregation would continue. But there were other cases that came out of Oklahoma territorial years that were successful at the Territorial Supreme Court. 2 were successful in overturning segregation law on grounds that it violated the 15th Amendment. As people tried to create the mechanisms to run separate schools, one solution that they had was to have separate school boards for the separate schools, and they wanted to have each race elect their own school board. Well, this was overturned on constitutional grounds because you can't prevent someone from voting on the basis of race. Remarkably, again, in the Oklahoma Department of Libraries, shout out to them, I was able to recover the notes of the attorney arguing this case. He traveled to Guthrie and stayed at the Hotel Royal and was preparing his briefs and notes the night before. Hotel Royal was, I think it's sadly not still there, but it was the site of where the territorial legislature met in the early years. So it was also where they held district courts and the Supreme Court. So these notes showed that he understood that they were in clear violation of the Constitution. Other cases that came later as the century turned challenged the threshold the threshold that people had to have to build another school, a separate school, as the minimum kept raising. Eventually, a case was brought by 2 of the territory's most prominent black attorneys, and a judge rendered a decision that was widely quoted in the territory as precedent, that even if there is but 1 black student, the board was obliged to levy a tax to build a separate school. So the standard became the norm around the territory. That became established law, that you had to build a separate school even if there was one. You couldn't have a child travel even to the neighboring community. Shortly thereafter, another Supreme Court judge declared educational access for all was an almost inalienable right. So I argue that this body of legal decisions, testimony, and briefings offer us today a surprisingly well-documented account of the perceived educational rights, one that most often extended to black children. And I argue that Oklahoma's legal activism allows us to recover a history where black families claimed education as a right directly to the federal government, and most importantly, had those claims affirmed in federal courts. So finally, the broader significance of my work. A lot of research about legal history of Oklahoma focuses on the 20th century cases that were done in concert with the NAACP. So, you know, people have written books and studied Ada Lois Scipio Fisher's breaking down of racial barriers at OU in the law school. People have looked at George McLaurin and him integrating OU's graduate program in education. And a lot of these studies, I think, overly focus on a top-down approach from the NAACP, whereas my research is really indicating that this ignores the large network of Black activists who were in the state from territorial times on. It ignores the fact that there were more Black attorneys in Oklahoma at this time than any other state. We had more local branches of the NAACP at this time. And so I argue, and even in looking at some letters between Roscoe Dungy and the national branch of the NAACP, you can see that he was the one who was really hand-picking litigants and putting them forward and urging the national branch of the NAACP to act. And so I argue if we ignore these earlier cases where many lawyers, Black lawyers and white lawyers, argued these constitutional cases, then we ignore the roots of this activism. And we kind of attribute it to a top-down approach, whereas these roots were here all along. I think it's also very tempting to look at the Dowell case, the Dowell decision, which, you know, was 30 years of litigation at the United States Supreme Court that forced busing at Oklahoma City Public Schools for 13 years. And then in 1991, that busing program was ended. And Thurgood Marshall, you know, gave a blistering dissent looking at Oklahoma's long history of segregated schools. And I think it's a fitting bookend that this case in 1991, I think a lot of people look at that and say, you know, racial hierarchy and the way it was established in Oklahoma was a foregone conclusion. That ignores this rich history of Black legal activism and organization and movements that were here from 1891 raising legal challenges. So I think, of course, these are important cases, but I think we have to look at their origins. I think the story of the individuals in the communities who used legal decisions and letters to the Attorney General as, quote, levers to wedge the school door open, calls into question the inevitability of this Dowell outcome.
1967, the Brown decision, Oklahoma's test case, January 1967, changed the law. Oklahoma had changed its constitution.
Right.
Sitting next to me is that test case, right here.
Oh, really? What is your name?
My name is Betty. It was Betty Vermeer at that time.
Oh, wow. I'm getting goosebumps. I'd like to talk to you. Yeah. Yes. Thank you. So.
Thurgood Marshall got Roscoe Dungy to fire up the people in Oklahoma City.
Yeah.
And they hit the court in 1-day trial.
Yes.
The judge says this is not going to be a 6-month trial. 1-day trial, and that was the test case.
Yes.
Broke the Brown's back.
Well, I know, and I think, again, this Oklahoma part of the broader NAACP, work has not been fully examined. I've been finding cases through my work with the NAACP, and these people are still here and sitting in this room, and so I would love to talk to you about that.